Mr. President, I beg to disagree. That is a decision of the court.
It is not reflected. That's why, Your Honor,
In any case, that is, we have precisely, we go through these caucuses and we decide on how to dispose of the motions. And this is what was agreed to be the ruling of the court on this issue. And that is confirmed by no less than the Senate President.
At any rate, gentlemen, with your indulgence, we are going to write a formal resolution. And this will be discussed again by the members of the court. So the records will indicate the ruling of the chair, which is actually a ruling of the Senate as sitting as an impeachment court. Now, the gentleman from Iloilo.
From Taguig and Pateros, Mr. President. From Taguig and Pateros, Mr. President.
From Taguig City.
Mr. President,
Sorry.
we just want to place on record na pag-usapan namin ni Senator Lacson na napanood na namin to kahapon parang nag-replay tayo. So obviously, ang ibig po sabihin, there is some misunderstanding with the ruling because I also was surprised when the prosecution stood up to make also a motion for reconsideration, but at the same time, the defense are also making some comments. Ibig sabihin po, parehong ayaw sa decision. Bihira po mangyari yon. So let me try to do my part in making some clarification. My understanding of the agreement in the caucus, without expounding, simply saying the understanding, ang ill-gotten wealth cannot be accepted as a charge, as a separate charge. Because tignan nyo lahat ng articles, walang nakalagay doon na graft and corruption, na ill-gotten wealth. Okay. So this court will not be accepting evidence to prove ill-gotten wealth as far as a separate charge. But as far as Article 2 is concerned, non-disclosure means hindi ka nag-file, or nag-file ka na hindi kumpleto, o nag-file ka na meron pong mga iniba or hindi sinama. Now, in the course of proving 2.2 and 2.3, kung maipakita na merong properties na naisama, na hindi naisama sa SAL, at pag napakita na yung mga properties na to ay hindi kayang bayaran ng legitimate income ng Chief Justice, then there is a presumption in law because there are Supreme Court cases that said, mag-shift ngayon ang burden. Magiging ngayon burden ng kabila to show that this is not ill-gotten. So in the sense, you are not proving the pagiging ill-gotten. You are still proving whether or not may full disclosure or merong complete disclosure under Article 2. That is my understanding, Mr. President, but I will stick to what the President said yesterday and the gentleman from Iloilo, because anything else we say today will be in the nature of a motion for reconsideration. Klaro naman po ang sinabi ng ating Senate President at klaro naman po ang sinabi ng ang clarification po ni Senator Drilon. So anything anyone else says here right now, unless any of the judges are asking for a motion for reconsideration, but yesterday we were unanimous. So ang pakiusap po siguro namin ay ituloy na po natin yung hearing, and let's not argue on this point already because it's already been decided, and we spent so much time reading your memorandum and discussing this on the floor already. Thank you, Mr. President.
Let me cut short this discussion. I just want to read to you the opinion of the ponente in the case of this is the case involving the impeachment case against Ombudsman Gutierrez. And a portion of the opinion of the court, of the Supreme Court, says, suffice it to state that the Constitution allows the indictment for multiple impeachment offenses with its charge, and I hope you will take heed of this. This is the rule of pleading that the court established, with its charge representing an article of impeachment assembled in one set known as articles of impeachment. Therefore, it follows that an impeachment complaint need not allege only one impeachable offense as a whole, but its charge must be represented by an article of impeachment. And that is the quandary where this court was in when we held the caucus, because Article 2 now was expanded from what was its specification and allegation when the grounds for impeachment were actually narrated in the articles of impeachment. So, with that, let's proceed with the trial.
Mr. President, may you recognize Senator Francis Escudero.
The
President.
gentleman from Sorsogon.
Before we leave the point, just so that we're sure that we are clear on the matter, Mr. President, I raised the point, as the chair conceded, that each article must allege only one specific act. Kaya nga po sa Estados Unidos, minsan yung articles of impeachment umabot na hanggang 30 o 40 dahil kada individual impeachable act, hiwa-hiwalay na article yon. But I raise a second question, Mr. President, which I address perhaps to the body and to the presiding officer. We are impeaching Chief Justice Corona as Chief Justice, I presume, not as an Associate Justice, not as an advisor to the Office of the Vice President before, not as Presidential Legal Counsel. My point, Mr. President, is this. Kahapon po, ang dami ko narinig na ebidensya kaugnay sa ITR noong 1992, noong 2003. Hindi po ba ang pinag-uusapan natin dito, and I seek the guidance of the chair and my colleagues, hindi po ba ang pinag-uusapan natin dito, acts of the Chief Justice as Chief Justice, not prior acts? Hindi po ba hindi natin pwedeng i-impeach ang isang opisyal sa mga ginawa niya bago siya naging Chief Justice? Halimbawa po, si Vice President Binay, kung magiging presidente, we cannot impeach him for acts committed as Vice President once he is already President. I admit, an Associate Justice is subject to impeachment proceedings and he's an impeachable officer. But now we are impeaching the Chief Justice, I presume, as Chief Justice. My question, Mr. President, is, limitado lang ho ba tayo sa mga ginawa at di niya ginawa na impeachable habang Chief Justice lamang siya? O kasama rin ba, dahil tila si Aklo yun sa pinapresentang ebidensya ngayon, o kasama rin ba yung mga nagawa niya bilang Associate Justice lamang o bago pa nun? Dahil tila ang ebidensyang pinapresenta po sa atin dito ay may kinalaman sa mga ginawa niya nung unang panahon pa. Except perhaps to establish a pattern or practice, but that was not part of the offer of the prosecution when they presented this and the previous witnesses. I submit, Mr. President, and seek the guidance of the presiding officer or the body, and as well as the parties as to how we dispose of this matter.
I will put that request under the advisement because I'll have to consult the members of the court. I must confess that the chair is not in a position to make a definitive ruling as to acts done by the respondent as an Associate Justice all the way to his acts when he was appointed as a Chief Justice. He was appointed as the Chief Justice of the Supreme Court only in
2010.
on May 17, 1910. 2010 rather, 2010. So, whether the acts that he did prior to that is, we'll have to study it, whether it can be covered. Offhand, I would say that probably it is relevant because he is both an Associate Justice and Chief Justice of the Supreme Court. And but I am not saying that that is a definitive position because That is my offhand reaction, but I'll have to study it.
Thank you, Mr. President.
Majority Floor Leader.
We have a brief statement
Just
from Senator Francis Pangilinan.
Yes, just very quickly, but again, subject to the final discussion of and decision of the court. Section 2 of Article 11, Public Accountability Public Officers. It states, the President, the Vice President, the members of the Supreme Court, the members of the Constitutional Commissions, and so forth and so on, may be removed from office on impeachment, for and conviction of, and so forth and so on. So it does not say the Chief Justice, it just says the members of the Supreme Court. And since Chief Justice Corona has been a member of the Supreme Court, a member since 2002, then I'd like to think that he falls square in terms of the jurisdiction of this court from
Nevertheless,
the time that he
We
became.
will not.